it's funny in a way because whenever... Is there anyone in here who did international relations as an undergraduate? You did?
Yes.
So hearing international criminal law as political is probably completely self-evident to you, right? But for lawyers, it isn't. It's actually something which is quite shocking to hear that a judicial institution would be political, because the idea we get from the separation of powers is that law should be separate from politics, and the judicial mechanisms should be separate from the legislative, the law-making, and from the executive branches. But in international law, all of this becomes a bit murky. So let's actually start off with this question then. If we think about our unease about legal institutions being political, what is the rule of law in the international sphere? What is the idea of the international rule of law? Because we have an idea of what the rule of law might be in a domestic sphere, but that doesn't necessarily translate onto the international. So what is an international rule of law? What would the aspirations be for an institution that claims that it is fighting for the international rule of law?
So it's supranational governance.
Governance. And governance means what?
Something like the UN. So everyone subscribes or signs a treaty to that says, well, you know, we're all, these nation states are going to agree to this, so each of them is enforced on you.
Yeah. So what kind of, if we've got the UN as sort of the most important international organisation, because most of the states we have in the world that are recognised as states are also member states of the UN. What kind of institution is the UN in terms of you say governance? Now that's not really a term that we're very familiar with in law. What is governance? What kind of an institution is the UN then? If you think about the rules.
Security institution.
Sorry?
Security institution.
Security, yeah. Again, not really a legal term.
Well, it's an international organization with increasingly possibly legal responsibility and international law.
Yes, so, okay, so let's think of, as I said, the rule of law in the domestic sphere is we have an executive, we have a legislative, and we have a judicative branch. Okay? The executive is?
The Security Council and the General Assembly.
No, we're on the domestic sphere. What's the executive branch? Sorry? Government. Government. Partly government, yes. Going to basics. Yeah.
Legislative is Parliament.
Legislative is Parliament. And the judicative, of course. Police, etc. The whole organ that bureaucracy, yes, that brings the legislative functions into action, if you will. Okay, so in the international sphere, let's start with the legislative. What's the legislative branch in international law?
Publicize the General Assembly?
The General Assembly, but with a problem that
It doesn't really legislate.
exactly. It doesn't really legislate because nothing that the General Assembly does is binding. And you'd expect legislative acts to be binding.
But is that each state, so, when they sign treaties, to be the legislature and stand on
Each state, when they
sign up to treaties.
Yes, right. So states sign up to treaties, and with that they cede some of their sovereignty to make decisions, which are binding, to that international organisation. Which means that that international organisation can, in a way, have legislative powers. But the UN Security Council has also acted as an international legislator. For example, when it comes to the funding of terrorism. So the Security Council itself has decided that there are certain ways in which states and banks are prohibited from allowing funds to flow which might have something to do with terrorism. So the UN Security Council is taking up that role in the international sphere. International organisations. So in terms of international criminal law, then we've got the ICC setting out, as we did last time, what international crimes are. It legislates on these issues through the Rome Statute. But of course, the International Criminal Court is also a judicative branch, right? Because it's a court and it makes decisions as to the nature of individual criminal accountability. So we've got the ICC, and then we've got the ICJ, the International Criminal Justice, and then we've also got the tribunals. But then, of course, again, things get messy because the ICTY and the ICTR were set up by
Security Council.
the Security Council. So the Security Council set up an international tribunal, which would not be a legislative function, itself not a judicial function, but an executive function, setting up tribunals. So the UN Security Council also acts as the executive branch of the United Nations. So in terms of an international rule of law, we've got a much more messy structure than we do here for the domestic sphere. And this, in a way, is a good entry point into our discussions about why the International Criminal Court is political. It's already, from its very nature, political because it was set up by an agreement through states that they would be bound by it. It wasn't set up through a government, it was set up through agreement. It was set up through agreement from these states that they would cede sovereignty when it comes to mass atrocities. Yes? Any questions so far? No. Okay, good. International rule of law. The ICC claims It is the institution which fights for the international rule of law, and some commentators have said that the ICC is coincident with the international rule of law. So might you think that the ICC is the institution which inhabits the idea of the international rule of law, or gives it meaning?
Because it's supposed to make accountable those who are breaking the rule of law or those who are acting against the interests of the international community.
Yes. So the key, what I was trying to get you to there, to think along these lines here, was that the ICC can only be the international rule of law if you apply this idea of the rule of law from the domestic sphere onto the ICC, as though the ICC were a judicial arm, as it is in the domestic sphere. But here we've seen it isn't. It's far too, the international sphere is far too messy to that, because it's set up through treaty, through agreement, through consent. So this might be the aspiration of the ICC to present itself in this way, but that idea is only doable in a fictional world in which we have a division of powers as we do in the domestic sphere.
But does the fact then that, obviously the ICC's approachable decisions and sometimes referrals and whatnot but does that mean that it's necessarily against the rule of law, or that it doesn't represent the rule of law, in the sense that people have been tried?
Yeah.
Obviously, there remains questions of imperialism and whatnot, but if you put that aside,
if we put imperialism the first time.
like just for now, does it still not uphold the rule of law?
Well,
Or
objectively.
Yeah, or in theory anyway.
Yeah, so that's where it becomes tricky. So I think up to now, it's just important to know that it claims to. And then we'll talk about what Sarah Noun and Walter Werner have said about this. And then think about whether there is any kind of hope for the ICC to actually act as an institution of the international rule of law. So for now we know it aspires to be seen, or it wants to be seen as an institution which upholds the rule of law, because it wants to be seen as an institution which speaks law to power, which puts a check on politics, as would be the case in the domestic sphere. But we also know so far that that analogy does not necessarily work neatly, because the international sphere is very different to the global sphere. Okay, so the way in which Sarah Noun and Walter Werner set this up is through taking Carl Schmitt's idea of the political. Now, Carl Schmitt, I don't usually like referring to him, but he's quite a trendy thinker at the moment, theorist at the moment. Who knows something about Schmitt? Other than for the reading. Has anyone come across Schmitt before today?
He did Schmitt in Roald Dahl Compass. So the same way. I mean, I know Schmitt is the name of it, so it's kind of like, it could be 1,000 of them in academia, but what's the last Schmitt I know?
Is it Michael Schmitt or is it something else?
Someone else. This is Carl. So, German dude, and he is it DT or TT? I don't know. He was a theorist in the early 20th century who theorized mainly about ideas of territory and space and power in relation to that. So you can see how it's relevant to international law and international criminal law, because international law is all about territorial disputes and about exerting power and so on. Schmidt is well known for theorizing about this, in that he collapses law into politics. So he almost says there is no space outside of politics for law, because everything is determined by power relations. So he is someone who would not believe in this distinction of power, because he would say the government, Parliament and the courts are not actually there to put a check on each other.
Is he a theorist of international relations?
Yeah.
Yeah. And is he a realist theorist?
Yeah.
Yeah, I think I'm also in one of my other essays.
That's good.
Just took me a while to...
That's where we're coming back. He is also quite famously he was an apologist for totalitarianism, for Nazism. You can see how someone like that...
Was he in Frankfurt School as well?
Sorry?
Was he part of the Frankfurt School?
Oh God, no. The Frankfurt School, they were a response to Schmidt. In a way, there are parallels though, because Adorno of the Frankfurt School, he also has this question of the exception in international relations. The question is, if there is any kind of crisis, how does the executive arm exert power? And often what happens is that the executive, whether that's the US president or whether that's some other form of power, in any kind of crisis, they would make inroads into any kind of check on power, because they say we need to centralise all the power so that any kind of threat from outside would be immediately responded to, right? So in a way, this is how Nazism happened, because although it was in a minority, it made a big fuss out of the communist threat, and then centralised so much power within itself that there then were no other parties and no other way of challenging that power. So the question is, how is power of the executive able to concentrate in such a way that all of the different checks on it might be lost? And of course, the courts have a key role in that. So Schmidt, he explained Nazism in that way without necessarily saying that it was a bad thing. He was just sort of, this is a description of the way the world is inevitably going to work. And so there was, of course, after the Second World War, a massive backlash against Schmidt, saying that there needs to be some accounting for morals in this, yeah? Some kind of accounting for ethical obligations. Okay, so he says then that the world is split into friends or enemies. And this friend-enemy dichotomy, according to Sarah Nouwen and Bartolana, can be nicely applied to international criminal law, and is an indication of the political nature of friend or enemy. Yeah? Okay. So, they then explain how the self-referral of Uganda to the ICC meant that it could brand itself as the friend of the international community, while then the LRA, the Lord's Resistance Army, the rebels to the Ugandan government, would immediately be branded as the enemies of the international community or as the enemies of mankind. And then, to test this theory, they then look at the situation in Sudan, which was referred to the ICC by a referral of the UN Security Council. So, Sudan is immediately branded as an enemy because it's being prosecuted because it's a situation before the ICC, and then the resistance or the rebels in Sudan would be friends of humanity. So it's not always that rebels are immediately enemies. It depends on how the allegiances in the international sphere are being played out. Okay, so friend or enemy, self-referrals to the ICC would immediately mean friend of humanity, and being a situation before the ICC that is investigated by the prosecutor, immediately an enemy of humanity. So I'd like you to think about how nicely this model works and when it might not work. So I'd like you to discuss that with your neighbour, thinking of conflicts in which this model works and ones in which it doesn't work. I'll put up the ICC's cases as well, so that you can have a look on the screen, so that you can have a look where that works and where that doesn't work. You can start discussing.
那个人的学说就是把那个敌人分，就是把那个冲突双方分为称为 friends 和 enemy， 然后就是说，你看就举那个文章里不是举了乌干达跟苏丹的那个例子嘛，乌干达就找那个 ICC 说要他那个什么，然后他就是 friends， 然后他的反叛军，然后他就是 enemy， 然后苏丹就跟他相反，苏丹的反叛军找他。然后他就变成 friends， 然后那个什么，他的政府军他就变成了 enemy。他问这个
英文
How does it works？
How does it work？
然后他什么时候他就不合适了？Yeah.
What's your idea? I'm not already read.
我也不知道呀。你想吧，从这个那两方是内战的时候怎么办？你比如说我也不知道。
Civil war. If two parties civil war, how to solve the problem? If the two parties civil war,
two parties
in civil war, who is the most international another country recognize it.
我觉得他这个首先是你有一方那个违背了那个什么那个什么国际那个什么
Human rights against the crime.
对，
Man
首先你得违背了它，那比如说那种不违背，那你怎么把它分为 friends 跟 enemy？我就这么瞎想。
First of all, what's your idea? He say should first say who is commit against humanity, right?
Mainly for just international crime, if no crime against the international rule. So who is the enemy and who is the friend?
I think from China experience should depend on who is the most number of internet another country recognize this country like the China in 1949 and if the almost of the country recognize this new country in the Civil War. In the Civil War, who is most recognized? Most number recognized.
Recognize.
承认呢
Recognize.
对吧
Approach me.
Do you understand?
Some part.
Some part. Yeah. I see again. Yeah, like
Wait a minute, civil wars.
yeah, in civil wars, like in China, two party. One is the community system party,
yeah.
another one is
Yeah,
yeah.
national.
But the national is recognized the new government.
没有啊，当时不是不承认。你看你美国为什么
你看
不承认？
number，美国那个 almost 一个非洲国家 ，Middle East country, Africa and UK. UK the first community system country to recognize the new government. So
是，那你是 ICC，怎么判断人？不是你是。
对我说的 for example 嘛。不是就大多数国家承认你的吗？你说 civil war
不是承不承认你，那就变成什么是国家了，能不能承认国家政府？他这个问你，就是两方，那你 ICC 里面，他就把。
Okay, so examples where this pattern works. Friend or enemy of humanity.
Well, we sort of thought that where the ICC, different enemy dichotomy can work where the ICC wants state cooperation, for example. So if somebody is labeled as an enemy of the ICC, and the ICC wants state cooperation in order to sort of bring the enemy to justice. If the enemy happens to be in a territory of another state, then the ICC can request that different state to submit or to arrest that enemy. So even though the enemy is not within the state where they are labeled as an enemy, but in a different territory, then state cooperation can work such that the enemy is arrested and brought before the ICC. So we felt that would be one instance where that friend enemy could work, because it becomes an enemy of not just that state or the ICC part of the international community as a whole.
Yes, okay, so when the ICC wants state cooperation, yeah?
Right.
And what kind of example were you thinking of there?
Well, it could possibly have worked in the case of Omar al-Bashir in South Africa, because he became an enemy with the national community, but South Africa did not cooperate, obviously. But in that instance, he was an enemy of the international community as a whole.
Yes. Yes. But the question then is, if the question is, if the ICC does the labelling then, is that less effective than if the states do the labelling?
Because the ICC is inherently not required to do anything because it will be making a political decision then. So if the state makes that link, it's even better for the ICC because they keep their hands off, but then it aids in the criminal procedures.
Yeah, okay. So we'll come back to that because, in a way, the friend-enemy dichotomy as it's presented on the board is the ICC being used as a tool. And this suggests that the ICC itself can use this dichotomy as well, if only in a very weak way. Okay, other examples of the friend-enemy dichotomy in yeah. Yes, absolutely. So it maps on quite nicely onto the case of Libya and Gaddafi, his son, and the security minister at that time. Yeah. So in the case of Libya, it was a referral by the United Nations Security Council, similar to Sudan, and Gaddafi was without question branded as an enemy against humanity, particularly because an enemy of humanity. So because the prosecutor at that time, still Luis Moreno Ocampo, went out talking, even before the arrest warrant had been issued, formally issued, talking about Gaddafi as the tyrant and the monster and so on. So it maps on very neatly to the Libya situation. Other examples where it does or it doesn't map on. What about Kenya? What do we know about the situation of Kenya before the ICC?
Well, there was so the chief prosecutor, Luis Moreno Ocampo, went in to conduct or to operate investigations as to the crimes that were committed at the 0708 post-election violence, and a case was brought up against the ICC, after the ICC against the current president and the vice president, but the cases have since been dropped because of what was called lack of evidence. So is the question whether it maps on Libya or not?
Yeah, so the question is, in the case, we've tested it against self-referrals. Uganda referring the case means it can then itself, the government then can be branded as the friend, and the opposition to its power can be branded as the enemy. It maps on quite neatly into situations in which there is a UN Security Council referral, because in that case Omar al-Bashir and Gaddafi here branded as the enemies, and then the opposition to them would be the friends. But what about in the case where the prosecutor acts of their own accord, the proprio motu powers that the prosecutor has? Does it work in that case that the prosecutor can brand those whose situations have then been brought to the ICC in the same way as enemies? And Kenya is a good test case for that. So what's interesting, of course, in Kenya is that the involvement of the ICC had a quite different effect, because President Kenyatta, who already had the arrest warrant on him, used ICC interventionism in his political campaign as a reason to vote for him, right? Because he said, this is Western interventionism, this is interventionism in our own affairs, we can deal with these issues on our own, we have courts here. So it backfired here. prosecutor being able to use this dichotomy for his purposes, in fact, Kenyatta was able to brand himself as the friend, with the evil ICC intervening into its situations. So here it backfired. When so, what does that tell us about the political nature?
It's all PR.
Sorry?
It's all about PR.
Yeah, that might be me influencing you with my with my language, choice of language. It's all about PR. I would agree, but yeah. Do you want to develop that a bit?
Well,
Why
the thing
was
about intention break, I see that in one of the questions for the next seminar, which was asked what's the purpose of Bensouda going on YouTube and
Yeah.
these interviews in front of the president that. And for me, it was just pure PR, it was about the image of the
Okay, I'm glad you see it that way too. Absolutely. So, what international criminal law does is it simplifies very complex issues, and the friend-enemy way of looking at the political context is a way of expressing that simplification that the ICC. This kind of a simplification of the ICC, but it's not just the ICC, of course, it's international criminal law in general. The pattern that we see emerging in terms of the friend-enemy is that the ICC can be used as a mechanism itself, but it, as an institution, when it tries to use this distinction between friend and enemy, it's only done so in a very flawed way, in a very partial way. So the question then really is the ICC a tool of the states which are party to it, and the states who are not party to it, or does it have any kind of function itself, right? How strong is its political nature itself? Is it distinct from the parties to it? And that goes back to the whole question of how it was set up as through treaty, as an institution set up through agreement and through consent. And that any state which is unhappy with it can then also itself withdraw. So, in the latest debacle with South Africa is that, and we'll be hearing from Brian about South Africa next week then, is that it has officially withdrawn its withdrawal, which is another sort of example of the ICC being used rather than the ICC itself being able to exert any political power itself. When it comes to friends and enemies of humanity, Palestine is of course a very good example of having a very difficult position there. So I think, if you don't mind, I'll just get your presentation up.
That is understand political nature.你还能选出后来的。
again, please.
Oh man, that was so scary.
林从上，按住了。
刚才不是开着没有？
啊，
他刚才是不是差点歘一下摔？
对呀，
It's on. Oh yeah.
就差点就废了，
Yes. There we go.
直接卡到2个睾丸。
你怎么敢告诉我这样？
能不能指老师讲不要同学发言好不好？
So first I should start with a bit of background about the Israel-Palestine conflict. So Israel became a state in 1948 and Gaza was under control of Egypt whilst Jordan was occupied by the West Bank. And then in 1967 was the Six-Day War that led to Israel gaining control of Gaza with the West Bank. And then the Oslo Accords of 1993 allowed the Palestine Liberation Organization to relocate back to the West Bank and Gaza establishing the Palestinian National Authority. But fighting continued, and it was not until 2005 that the Israeli Prime Minister removed Israeli soldiers from the Gaza Strip, stating that Israel had no control over Gaza. However, NGOs such as Amnesty International and Human Rights Watch still consider Gaza to be under the control of Israel, as it controls air and waters and the movement of people and goods into and out of Gaza. And then in 2006, Hamas beat Fatah to win the election in Gaza, and the Palestinian Authority are present in the West Bank at the moment. Yet Israel still have a large amount of control over areas within the West Bank. And there's obviously also disagreement over Jerusalem because of its religious importance. In 1980, Israel declared Jerusalem as capital. However, no other state has recognised that. And in the legal consequences of the construction of the wall case, the ICJ said that the East Jerusalem was occupied Palestinian territory. And then there was the Gaza conflict between July and August 2014, which was a 50-day conflict where more than 2,100 Palestinians were killed, and most of them were civilians. And then the 1st of January 2015, Palestine declared that it had accepted the jurisdiction of the ICC since the 13th of June 2014, in conformity with Article 12.3 of the Rome Statute, meaning that the ICC could investigate any crimes committed after that date, which included the Gaza conflict. Palestine exceeded the Rome Statute on the 2nd of January 2015, and it officially went into effect on the 1st of April 2015. Israel is not party to the Rome Statute, but individuals could be tried for crimes that were committed on Palestinian territory. Israel also claimed that Palestine had chosen a path of confrontation by joining the ICC, and that would affect peace negotiations. The USA are also against Palestine's membership to the ICC. Palestine being able to become a member of the ICC and its it had a non-member observer status at the UN. Because it clearly then had an ability to enter into relations. And Mendes argues that at the very least, the fact that they've now got that non-member observer state, they have enough legal personality to be party to the Rome Statute. Yeah, obviously there's still a lot of dispute over whether Palestine is actually a state or actually should be allowed to have membership of the ICC. And there was a previous preliminary examination from January 2009 to April 2012, which was lodged by the Palestinian National Authority. But it was concluded that as Palestine had not signed the Rome Statute due to it was then an observer entity of the UN, there could be no further investigation, which I think it was in the Ashgate paper where it said that politics trumps the right of Palestinians, which I think can be seen in that fact that it didn't have this status at the UN meant that it then was not able to take anything to the ICC. And then on the 29th of November 2012, Palestine was given its non-member observer status, which the ICC said that it then would be able to join the ICC, which obviously it did in January 2015. And then on the 16th of January 2015, the Office of the Prosecutor opened a preliminary examination to see whether or not there was reason to pursue a formal investigation. A preliminary inquest looks into whether there have been crimes committed and whether they are brave enough to warrant ICC investigation, and to see if national authorities are carrying out their own investigations, given that the ICC is a court of last resort. And then just sort of talk a bit about like how long the preliminary examination will actually take. And there's no way of really telling, as you can see there, with the table that's on there, they can go on for years or can just be months. Palestine have asked the ICC to speed up the examination, but the fact that they may not is just an obvious problem of the ICC. However, it's also been suggested that the examination will be very long, given that Palestine have not themselves formally referred the case to the ICC, which they now have a right to do as members of the ICC. Former ICC official went as far as to say it's hard to imagine the prosecutor ever opening a formal investigation into Palestine without a referral. Israel, although are now cooperating, they've been very hesitant to be involved. Again, all of this seems to highlight how politicised the ICC is, as whether or not there is a formal investigation should just depend on the facts, not on the politics of the countries of Israel and Palestine. Additionally to that, it's argued that the decision by the Security Council to not refer Palestine to the ICC like it did with Libya is one that is politically motivated. So what next? If there is enough evidence that a formal investigation will be opened, the first report that was published on the preliminary examination, whilst not conclusive, did highlight crimes committed by both Israel and Palestine. The ICC have visited Israel and occupied Palestinian territories to gather evidence. Israel has stressed that they do not have to allow the ICC to investigate on Israeli territory, as the ICC has no jurisdiction over them. Not only will the ICC be looking for evidence of any crimes committed, but they're also looking to see if there's any reason to suggest that a national investigation would not be possible. And then if it is decided that Israel can fairly deal with such cases, then the ICC would not formally investigate.
Thank you. Great. Does anyone have any questions?
Yeah, I just was wondering, there was a slide that said that Israel had said that Palestine had chosen a part of consultation.
Oh yeah.
Why were they saying that? Was it because Palestine had accepted jurisdiction of the ICC? Or?
Yeah, it's because they've decided to try and take the matter out of the domestic sphere that it was in and take it to the ICC that they disagree with. That, as obviously Israel aren't members of the ICC, they just believe that that's an aggressive approach of Palestine to do so because they don't believe that's the route that should be taken. It should be peace negotiations, which obviously haven't really worked.
But then later on the slide said that there is unlikely to be any investigation unless Palestine itself refers the matter. Yeah. So what were they doing then that Israel called them? Said it had chosen a path of confrontation. Was it referral or?
No, it was just generally them deciding to sign the Rome Statute.
Right.
Yeah.
Okay. I just wanted. I was confused. Thanks.
Yeah.
Any other questions? Okay. Thanks very much. Yeah. So in terms of Israel and Palestine, not only does the political nature become so evident, but also the way in which the ICC attempts to assign the friend-enemy dichotomy to particular states. So if you remember from the reading from Talk Riva, he set out how a lot of the negotiations at Rome had actually been about reassuring the US and Israel that no investigations would be opened against any of their nationals. But there remains, as Ruth said, the possibility that even as non-member states, crimes and atrocities could be investigated if they happen on the territory of a member state. Now, in the case of Palestine, that is particularly difficult, of course, because, or particularly contentious, of course, because Israel has been impeding on the territory of Palestine through its settlement policy. And so the very sort of delicate nature of Palestine is intimately attached to that question of territory. So if we sort of take a step back from that, in this case, Palestine is trying to utilize the ICC as a forum to have, in a way, their precarious nature in international affairs recognised. Yeah, but at the same time, they're up against. It's a real sort of David and Goliath kind of relationship, because they're up against so much resistance of the powerful states. The US having historically always shielded Israel, and the ICC as an institution being very reluctant to do anything that might offend the powerful states. So we can see that one of the main things that the ICC has always claimed in terms of its non-political nature is that it says that it insists that it is independent of the UN. But we can see that there are more and more situations in which the ICC and the UN are very closely related, and in fact where the ICC depends on a certain status being recognised by the UN. So we've got that with the crime of aggression. We said the crime of aggression is recognised as a crime in line with how how it's interpreted at the UN. We've got that with UN Security Council referrals, which can go straight to the ICC. So the UN has the power there to send issues to the Office of the Prosecutor. And then we can see another relationship emerging here, in that the UN has a hold on the most privileged aspect of international law, which is statehood. And since Palestine is not formally recognised as a state in international law, it also continues to have a precarious situation in other organisations. So using the ICC as a means of labelling Israel the enemy and itself as a friend is very much dependent on being recognised in the international community in the first place. And this is absolute Schmitt. This is fully in line with what Schmitt would have said, because for him, this friend-enemy dichotomy can only be is the privilege of power and statehood. Yeah, does that make sense? So Palestine, because its status as an enemy of humanity, which dates back to US and the US and its protection of Israel, is pre-existing any kind of labelling it can do itself. So the ICC then again shows itself to be quite a weak instrument in that labelling. If we go back to any other questions on Israel and Palestine for now, I mean, of course, we could spend a whole semester just talking about Israel and Palestine. But questions on Israel and Palestine at the ICC? Another very interesting aspect there is that there have been several commissions of inquiry about the conduct of Israel. And usually commissions of inquiry would always recommend referral to the ICC or an establishment of a tribunal. It would always in some way recommend criminalisation. That's just the way commissions of inquiry have gone. And the Israel-Palestine conflict is a glaring exception to that, because no one really dares to go near it in terms of any kind of judicial decisions from that. So we'll see.
I just wanted to quickly ask, so in an event that Palestine refers the situation to the ICC itself,
Yeah.
is that going to be more beneficial to the case in terms, because there will be a clear definition that Palestine is a friend of the court and Israel is a clear enemy. Is that going to be more beneficial to the ICC prosecution of what is happening in Palestine, as opposed to if there is a decision that comes from the prosecutor themselves to conduct investigations into, I mean, what has the chance of a best case scenario?
Yeah, well, as we said, it's very unlikely that the prosecutor would themselves take on the case. And it's just politically very, very unlikely. If they self-referred, then they're obliged to start an investigation at the very least, and then we would see. So the last time they came back and said, on a technical issue, they said, no, Palestine's still a state, can't, you know. So we will see. Historically, international courts have backed out of any kind of big decisions like that. Certainly at the ICJ, that's the pattern. So we will see. But in a way, it confirms what we already knew, that international organisations are political, and that's no exception for international courts and tribunals. Now, what we do with that question then is the next aspect. So, what do Noel and Bana, what do they suggest? What do we do with this knowledge now that there is a friend-enemy dichotomy?
Knowledge, political nature.
The acknowledgement of the political nature, where does that lead us?
That it can actually help the ICC in its prosecutions, and that sort of international laws should not be seen as inherently unpolitical, but then that it's the fact that it's actually political can be a good tool in terms of using international law and the ICC.
Yeah. This is sort of what they argue. Do you find that convincing?
No.
Why not?
Well, because I don't find it convincing at all, because I mean, if you admit that international law can be enforced more properly or can be viewed, looked at from a political lens, then you're in essence admitting to hegemony or political hegemony, because that political nature of international law is only going to be effective for a very small group of segment of states, but it's not going to be effective for the grand scheme of things. So I think it is in essence hegemonic and not counter-hegemonic.
What's your opinions on that? So they suggest at the end the ICC should just acknowledge that it is a political institution, and that acknowledgement itself might actually help in some way. What, from an international relations point of view, does that lead us anywhere?
No, surely they have just admitted their rights. I mean, when states just leave, they withdraw from the treaty, surely. That's
sort of what Brian is saying, because then if they admitted it outright, would that also be an admission to privileging some states' interests over others?
The legitimacy was an issue of the district exercise.
Sorry, because it shows.
The legitimacy because it shows the subject to bias.
Yeah.
I was going to say, kind of seems to go against everything the Rome Statute did. The intent of the drafters wasn't for the ICC to be political, so it kind of undermines everything that the Constitution stands for.
And I think that we kind of always forget that, because when I talk about Uganda and some countries have self-referred, is that there is nothing to gain from that. But one thing I've always looked at is the fact that behind each self-referral or behind each ICC investigation, there are people who are victims of horrific crimes. And I think if those people can be brought to account, obviously accepting that the ICC is political itself does not mean that the ICC does not provide some sort of justice, because I'm not sure about the evidence on whether Africans say the ICC is a good thing. But my point is always that behind every investigation is because something has happened and we need some sort of accountability for those involved.
Yeah, the problem is for the victims, and this leads me to a short YouTube clip actually that I wanted to show you. Yes, we should think about the people who are affected by this, and whether what we know about victimhood is we don't know whether victims of international crime find international courts helpful at all. We don't know that. There's just no empirical evidence to let us say that with confidence. What we do know with confidence is that victims do like to have their stories told. So the question is, does the International Criminal Court, do the international courts and tribunals does it affect victims at all if they admit to this being a political context? I would suspect no, they don't care. They wouldn't care whether the ICC says it's acting in a political context. I would probably say victims of international crimes don't care. But what they do care about is the way in which their victimhood is being told. Now the problem might be that if it's an inherently hegemonic institution, that has a knock-on effect on how victims are portrayed and what their experience is in the court. This leads me to, I'm not sure whether Edward Said is Edward Said and Orientalism, is that have you heard of this? Okay, so let me just get this clip up. Very short one. In terms of how the other, which would be victims of crime as well, how they're portrayed through the news. But I would like you to think about what role international courts and tribunals can play in this as well.
From the beginning of Western speculation about the Orient, the one thing the Orient could not do was represent itself. Evidence of the Orient was credible only after it had passed through the refining fire of the Orientalist work. Edward Said, Palestinian intellectual, literary theorist, historian of the colonial narrative. Said explained how colonialism works, not just through armies, but through literature. Not just through conquest, but through anthropology. Not just through oppression, but justified through narrative. He showed how the West painted a picture of the East. snake charmers, belly dancers, thieves, the exotic, the sensual, the depraved. Said saw it in 19th century Western literature, and you can see it across modern culture. Switch on the news, read the newspapers, look at the images. What stories are you being told? Us versus them. The rational versus the irrational. Civilization versus barbarism. Africans, corrupt despots, starving victims. Latin Americans, drug lords, football players, dictators. Arabs, terrorists, misogynists. Asians, software engineers, religious fanatics. How does it feel to be fixed, captured, framed? Think of Orientalism as a lens. Use it when you read the media. Spot the stereotype, decode the fiction, unlearn the myth.
Okay, so Said, and of course it's relevant here that he was a Palestinian theorist. He wrote this a very influential book called Orientalism, in which he unpicks ways in which stereotypes are constructed and then again and again reproduced. And as the clip said, this is not just through outright colonialism, but also in the literature about these places, in anthropology, in all sorts of different disciplines, and of course also in law. So the question is, can a victim of international crime in a court which has been set up through a Western gaze, can a victim of international crime really have the kind of forum to actually step out of these stereotypes? Or is it that these institutions have already been set up with a view to stereotyping the victim as passive and inactive, and those who intervene as active and heroic, and those on the side of order and law, and the reverse then for the victims. So that's what is unclear, whether if we focus on the victims, we're actually presenting a forum that is useful, or whether it just continues to reconstruct this stereotype. So Orientalism and Said. I can definitely recommend reading it or reading excerpts from it, because it was really the first time that the idea of the other had been was theorized in that way, because it became apparent that Orientalism didn't mean anything to those who lived in these spaces. It only meant something in the Western imagination. Said, coming from Palestine and grown up there, realized that the ways in which the Orient was presented, and Orientalism for me is geographically, not just the Middle East there. But he realized that there was a huge disjuncture in the way in which his life was presented in other media and his own experience of it. So this is what made him write this. So, in how far is international criminal law just reproducing this Orientalist idea of the other? and in how far a victim is actually able to step out of that. And that's kind of a little bit, I don't know, maybe that's in tension with what we were saying earlier about international criminal law, because that gives it quite a lot of power in a way. So anyway, any other thoughts on Orientalism and the ICC stereotypes? We'll be speaking more about that when we talk about, particularly when we talk about ICL victims in week 9. And I'm curious, I'm genuinely curious to hear what you think there. So what I wanted you to do then, in a way, sort of, I initially wanted to start with this, but maybe it's good to do this now, is for you to make a list of the ways in which international criminal law is political. And again, feel free to discuss that with your neighbour. So we have, through the dichotomy of friend-enemy, we have sort of looked at political through the lens of Schmitt. He said this is politics. Politics is assigning a friend and an enemy. But politics can be other things as well. So I'd like you to just make a list of what you think is part of politics in international criminal court tribunals.
Part of politics 是什么？
是吧
？Politics
就是 politics，他说 politics can be the friend and the enemy。
还有问题是 make a list of part of politics。
就是除了敌人和朋友之外 ，politics 还可以是什么 ？Maybe also can be the ideology. The different belief with different like Middle East, like Europe. Expect the enemy and friends. What is the different perspective to think about the politics? Expect the friend and the enemy. What is the others? So first of all, maybe ideology. Interest, profile. Yeah. No profile. The connection between two countries, the trading. Yeah.
Right then, which other ways is the international courts and tribunals political? What other ways are there of thinking of them being political?
Political ideology. Sorry.
No, you go.
Ideology.
Ideology, yes. So what does ideology What lens does ideology give to us that political doesn't? What do you mean by ideology? Sorry.
Ideology, because different ideology countries have different benefit and different power.
Yeah. And so if we see the International Criminal Court as an ideological project, what does that mean?
I don't know, sorry. I don't know.
Okay, Ruth, would you like to?
I was just going to say, generally, the fact, like, what you were saying earlier about the ICC being part of the legislative and part of the judicative, and then the Security Council setting up the tribunals, and then you could maybe argue that the tribunals themselves are set up to kind of appease political struggles within a state, and they're set up after a time of conflict, and their reasoning for being set up, although it was justice, is also to
Yeah, so them being political means that they are reactive, and that courts would usually be set up not as reactive to crises, but as a way of organising the society. Yeah. Other ways in which the ICC is political.
Like some of it's so if it's an arrest warrant, and for the other states to cooperate, sometimes they are dictated by what politics does for them. So, like the Al-Bashir example was that South Africa, just because anything with the ICC, there's a political decision decided not to give him to the ICC.
Yeah.
Or is that nothing to do with the court?
Yeah. How's that different to the friend enemy? Yeah. So we're thinking of other ways in which it's political.
So without the friend enemy.
Yeah.
Well, we said the crimes of which the ICC has jurisdiction for crimes are political in the sense that they exclude some of the crimes that are committed by the ordinary global north and only include crimes committed in the global south. So it's not just the decision to include 4 crimes that are predominant and prevalent in the global south, the political decision in itself.
Yeah, absolutely. Political can also mean not necessarily a perspective on power politics, but it can also mean a perspective of race, for example, right? Which is sort of the introduction of that to from Orientalism, yeah?
I wouldn't say the idea of individual responsibility arising from ideological.
Yeah? So, okay, so I'm going to ask you the same question. What does an ideological lens give to us that a political lens might not?
Fancy the way around.
Yeah.
Maybe a political lens is more about power.
Yeah.
As opposed to, an ideological lens is necessarily about power.
Yeah. Yeah.
I don't want to go any further.
Can anyone try and articulate what they think an ideological lens would give to us that politics doesn't necessarily?
Ideology lens.
So the Talk River has written about this and has lamented the fact that international criminal justice is described as political. Because he says that prevents us from asking ideological questions. Now the difference here is that ideology concerns the systematic construction of a particular privilege or of a particular othering. So political can be the outcome of a political conflict can be incidental that then one is privileged over the other, but ideology gives us that lens, that systematic lens. Does that make sense? Yeah? So ideology would have something to do with understanding all of these different outcomes in a particular way as symptomatic of structures. So Torkruber says we should just stop talking about the fact that international criminal justice is political, because it only ever allows us to focus on individual cases, and we can't then access the more systematic inequalities which are going on. Yes? No? Yeah. So that's why when we talk about the politics, we can talk about it from different points of view. We can talk about the gendered aspect of international criminal justice. We can talk about the racial aspect. We can talk about class aspects. But what we can't do is understand that together in a systematic way, which is why I wanted you to think about other ways in which we can talk about politics other than just the friend-enemy dichotomy. The friend-enemy dichotomy doesn't allow us to think in systematic terms. It's just on an individual basis who wins and who loses.
Well, you know, so like the whole ideological thing then, is it? So obviously the fact that there are, you know, obviously, like I said before, structural issues that mean that when conflicts do happen, then that's when the ICC. Or do you actually think that the ICC, there's like a meeting where they say, oh look, we want to target so and so? Because
yeah, well I would subscribe to the view that the problems of the ICC are symptomatic of larger structural problems, but that doesn't mean that the ICC is full of puppets and they don't know what they're doing, or that they're somehow, that they have meetings where they say, well, how do we give hegemonic expression to this and that? I think that most of the people working there don't know that they're operating within these structures, and those who do know that they were operating within them don't feel that they can resist them. But that doesn't mean that the ICC could still be a mechanism for resistance, and could be a way of resisting hegemonic power. It just chooses not to be. So with Palestine, we've seen that with the ongoing investigations into situations which will never come to fruition. We can see that. So I think it is choosing to align itself with the harmful states. Yeah. But it could, it could be. So when last summer, when the Chilcot inquiry found that Tony Blair had in fact deceived everyone about Iraq, least surprising piece of news of last summer, and there was this whole question of should Tony Blair be sent to the ICC. You know, I was talking to Torkruber about should we write something that there's no point in sending Tony Blair to the ICC because that won't change anything. The ICC still is just this symptom of greater things, but I couldn't even convince myself of that. So I think sending Tony Blair to the ICC might send a message. It might be a form of of resistance. It might, sorry?
Make or break the ICC.
It might make or break it, but that might be the ultimate test of it. So I think it could have potential because it's got such a big stage and because it's got such a big audience. It could have the potential for resistance.
But then what grounds will it be tried for?
Well, Tony Blair, for the countries in Iraq.
Oh, so then, in terms of the crimes under the wrong statute, you then not require some sort of intent or whatnot before you can establish that there is active guilt.
Yeah.
So genocide and
Of course. Yeah. I don't think you would be able to do genocide, but war crimes.
okay.
Yeah, crimes against humanity probably as well.
It's just South Belgium as well.
Sorry?
Just South Belgium was the reason to go to the war, that's the war crimes.
Yeah. Crime of aggression. Yeah. That would probably, if the crime of aggression ever comes to fruition, then that would be probably the most urgent one, because that's the use of bellum, that's the one which is the illegally waging war. Am I doing? I don't know. I don't know. Have you had the Russell Tribunals? Russell Tribunals? Is anyone? Usually I get someone to present on them. I forgot this year. So the Russell Tribunals are actually really interesting attempts at doing precisely that. So they were set up by the philosopher Bertrand Russell, together with Sartre and a bunch of French thinkers and avant-garde intellectuals. They managed to get funding for this project, and they set it up as a response to the Vietnam War. They wanted to put America and American officials on trial for crimes which had been committed in Vietnam. And they invited a bunch of witnesses and victims, and they staged this tribunal without any kind of democratic legitimacy. They didn't even try to legitimate it, other than saying, we are using this court as a tool to show what hegemonic power means, how the hegemon decides usually on what is aggression and what isn't. And I think it was 2 years ago, there was a sort of revised version of the Russell Tribunal for Israel-Palestine. So for the Palestinian people, again, putting with witnesses and so on, and a judgment, and it's a form of trying to find some kind of hope in law and some kind of hope and just idea of justice within the legal platform. So, yeah. Russell Tribunal, an interesting sort of project. Yeah. Okay, so, Levin, the Kosovo Relocated Specialist Judicial Institution is an interesting one because it is an attempt at addressing these political limitations of the courts so far. And we don't know, again, we don't really know whether that will be successful or not, whether it's sort of stillborn from the beginning, but it's an interesting.
So it's a proposed court Kosovo set to try alleged crimes with the KLA. The KLA were like the Kosovo Liberation Army during the Kosovo War. These alleged crimes took place between 1990 and 2000. The Kosovo War was largely fought due to the opposition between ethnic Albanians and ethnic Serbians. There was a power struggle over the area. The Serbian population felt that they should have held sacred lands that were in control by the Albanians, and then fought for tensions rise. Background to the war. The KLA were an ethnic Albanian paramilitary organisation whose stage was qualified as an armed uprising. This was due to the atrocities committed by the Serbian police forces, paramilitary groups and the army. This led to the incident when worldwide news, the fleet of refugees and the international community called for a ceasefire. However, the ceasefire was not correctly implemented by Milosevic, the president of Yugoslavia at the time. It only allowed the KLA to regroup and renew their attacks against the Serbian forces. After introduction by NATO of strategic airstrikes against the Serbian military targets, criminal prosecution of the Serbian leaders was therefore put forward to the ICTY. This gives sense that there is an element of justice in the case, well, up to now anyway, because the creation of this court could lead to it being reversed on its head. Background to the court: the UN Security Resolution 1244 set up the mission to restore humanitarian peace in Kosovo, provide the safe return of all refugees, displaced persons from their homes. It also gave power to the United Nations to set up the Interim Administration Mission in Kosovo. This led to the creation of the European Union Rule of Law Mission in Kosovo, which manages the European resources in the state with regards to the aim of the diplomatic mission, otherwise known as the EU-LEX. The establishment of the special chambers of the Specialist Prosecutor's Office relates back to a report on the inhumane treatment of police people and illicit trafficking in human organs. This was a report made in 2010, which was approved in 2011 by the Parliamentary Assembly of the Council of Europe. The report expressed the concerns that serious crimes have been committed by the KLA, especially the trafficking of human organs, and so a special investigative task force was created. A little bit on the working of the court. The court was established through the modification of Kosovo's constitutional law, which was seen as quite controversial because obviously constitutional law is hard to change and provides a few problems. With the focus of the law 05L053, this was a law that aims to protect fundamental rights and freedoms of the people. Also, it aims to secure independent, impartial, fair criminal prosecutions of those crimes reported by the Council of Europe. The specialist chambers will construct a judicial chamber staffed with international personnel only. No Kosovo judges or prosecutors will be involved, but funding comes from the EU and also comes through the court system in Kosovo. So basically, there was four courts that it goes through. Each level is attached to the system in Kosovo. The basic court of Pristina, Court of Appeals, the Supreme Court, and the Constitutional Court. The Special Chamber of Constitutional Court shall deal exclusively with constitutional referrals relating to the Specialist Chambers and Specialist Prosecutor's Office. Each have additional special chambers which will deal exclusively with criminal proceedings relating to the reports of organ trafficking. Judges will be only appointed by the European Union Rule of Law Mission and not by the Kosovo domestic system. This is to avoid what is seen to be corruption or other power struggles in the area. The specialist chambers of jurisdiction over the crimes against humanity and war crimes under international law, as well as Kosovo law to the extent that it relates to all the crimes mentioned in the report. This institution is very different in other ways as well. It's not set up like a tribunal. Rather than being constituted by a mixture of foreign judges, as already said, staff prosecutors and funding all will come from the EU as well. Every other detail seems to be domestic to Kosovo, which kind of shows like a hybrid court in a way. It would seem that through the natural makings of the institution, it's not really an international tribunal, yet a national court of Kosovo that works outside the countries. The institution is being held at The Hague, just as the ICT was. This can be said due to the problems of corruption in the area and maybe the protection of witnesses and other personnel crucial to the evidence given. There's two different approaches to this, the defining of this court. One says that the mixed panels composed of both domestic and international judges is only a way of defining a hybrid court. Therefore, the specialist chambers will be a purely international tribunal. The other is that, as it's established by Kosovo law and operates within the Kosovo justice system, then it is purely domestic. Whatever the view is that we found in this court, as it progresses, there's only one thing certain, that's there's a possibility of the principle of mixed justice kind of being squashed here, because we've got both Serbians and Albanians being trialed, so there's no real winner in the case. Even though the Albanians will seem to be successful in the case, they still have to be brought to trial. The the court is still in the process of establishment. All the judges still need to be appointed. I think at this stage only the president's been appointed. That was in December 2016. According to the website that gives information on this, the EU's website, it's expected that the processes will be completed by the first half of 2017, so it's something to look out for. But yeah, basically the court is kind of dealing with, like I said, the political kind of parameters here, because processing the Albanian paramilitary organisations kind of shows that just because they won the territory in a way, they won the war in a way, they still could actually be prosecuted for the crimes they committed while winning that war. So,
Great, thanks very much. Does anyone have any questions for them? It's so confusing, isn't it? Because it's all specialist tribunals or a specialist court or a specialist, lots of specialists. Yeah, so in a way, I think what's interesting with this new project is that it's again trying to, we've seen so many different forms and formats of international criminal justice. We've got the tribunals, which were set up through the Security Council, and that's unlikely to happen again because now the way the permanent 5 members are again politically somewhat in a deadlock, that's just unlikely to repeat itself for the moment. Then we've got the permanent International Criminal Court, then we've got various forms of hybrid courts, so Special Court for Sierra Leone, which had partly international, partly Sierra Leonean or African judges, the ECCC, the Extraordinary Chambers of Cambodia, which were partly connected to the Cambodian courts. We've got Ugandan War Crimes Division, which is part of the High Court of Uganda, and now we've got this EU-funded new hybrid kind of institution. But it is new in that both sides of the conflict are able to be tried there, which is a novelty for international criminal justice. So we will see what comes out of that, and it's sort of to be. I'm sure you know about the Kosovo conflict and the humanitarian intervention in Kosovo at the end of the 90s. It's an ongoing way of the EU somehow trying to deal with its involvement through NATO and so on in the Kosovo intervention. And this is just sort of the latest chapter of that. And it's been through all sorts of different courts, and it's really sort of the Kosovo issue is really sort of the playground of international lawyers. So we'll see what happens with that. So it's an interesting new. I think recently was it that another judge was appointed. I seem to remember something.
Well, I find it was only the one at the moment, but it could have been.
Yeah.
Another one. It was hard to find. There was loads of different kind of like debates about it.
Yeah. I think I saw some. I'm not sure. I'll have to double check as well. So, but what we know is that there will be no local judges, only international judges. So only those who are already on the international tribunals seen and who sort of benefit from this tribunalization anyway, which is where it's so convenient that it will also be in The Hague. So often, as with the Special Court for Sierra Leone, when that moved to The Hague, and with this court and all the other courts, there's always these arguments why it should not be in the place where the conflict took place because of corruption or because the witnesses might be endangered and so on. But there's never, on the reverse, any mention of how The Hague benefits from having all of these tribunals in one place. So that's another way of sort of The Hague is branding itself as the global justice city is another sort of perspective on that, which is usually ignored. Anyway, okay, so I think we'll leave it there by saying that international criminal law is political. We know that in various ways, but it may also not actually be very helpful to say that it's political, because rather than being a constructive way of seeing international criminal justice, that it should just admit to its political nature, itself, speaking about international criminal justice as being political could actually inhibit us from seeing larger structural issues at play here. Okay, so thanks very much, and then